slope assessments to amend it since it's now springtime and the data was collected in dry season last fall, sometime in September, I believe. And while I know that you can largely determine the boundaries anytime during the year, soils professional can make good approximations, there may nevertheless be uncertainties, and if he could go out and amend it in this season, say before May, that would, I think, reduce much of the uncertainty. So,
well, there are just a couple of things I would say. I mean, the EAC memo doesn't even cite a source for the idea that there's something wrong with this. They say there are varying maps that are out there without identifying what they're talking about. That is not a basis to have my client go out and spend tens of thousands of dollars to reclaim wetlands when there's a scientist who said that's where they are, number one. And number two, if there were minor variation here, again, this isn't the plan we're asking to build right now. You're making a determination whether, based on the information you have, based on what's required, this is the maximum number of lots we can get so we can go into the design phase.
Right, but if the wetland did extend beyond the currently shown boundaries, perhaps one or two of those lots would not be valid sites, and then the number would be reduced. Or perhaps the wetland is smaller than is shown, and you'd get a greater number. We don't know how it would turn out with an amended
well, I just want to
analysis.
I want to give you my feedback.
This is Mr. Zappi, the principal of the applicant.
These aren't approximated. They were soil test taking, vegetation. It was all done within the Town of Ossining Wetland Code. Site-specific. Guy spent days out in the field, flagged it. A surveyor then went out and located the flag. We're not winging this. We're not guessing.
I know that. Yeah.
How somebody can say, and this is part of my disrespect, so to speak, for the Conservation Board here, is they make accusations without being able to back them up, without going to the property. This is how wetlands are done. They're not done based on looking at other people's maps. They're not based on peekaboo through the property. It's based on a professional soil scientist going through the property. We have done that. I'm a very experienced developer. We've been held up on this project, and I have done what everything is required by the town. And the town is just delaying the project. You have all the technical information that's signed and sealed that is accurate. For you to support somebody who thinks they have a map, who are in some other industry, who come and say this, is mind-boggling to me. I've been doing this for 30 years. It's mind-boggling to me.
I'm not supporting one side or the other. I'm just saying it's springtime. I know wetland boundaries change. It would be great to see an amended.
Yeah, but your code doesn't provide for that.
I'm kind of a little bit surprised to see this comment in the letter from the EAC. I don't know if the public is aware of it. Certainly the EAC is aware of it. The planning board sat down with the EAC and the supervisor, and we went through this matter thoroughly, and I thought we had convinced the EAC that the wetland boundary that's shown on the map is accurate, and the wetland mapping that the EAC was putting forth was based upon gross mapping, not work that was done out in the field. The work that was done out in the field, we believe, is accurate. We have an environmentalist at our firm. We checked the wetland mapping. As a matter of fact, we basically wrote the wetlands ordinance for the town. And the sources that the EAC are citing are not particularly accurate. I've got the mapping that was used by the EAC in my file here. I've got the environmental assessment form that went along with the mapping used by the EAC in my file here as well. And I thought we had put this matter to bed, but apparently not. And I don't really understand why.
Please, for some of us who have not met you before, could you identify yourself?
Oh, sure, I'm sorry. My name is David Stolman. I'm the president of the Frederick P. Clark Associates. I've been coming to these meetings for the last 30 4 years, 37 years?
I know.
Since 1977.
Thank you.
Okay. I'm Howard Fleischer, resident on Fano Road, and somewhat of a concerned citizen, part of a group of concerned citizens called Concerned Citizens of Ossining. And I just want to address two things, and then I'm going to turn, if I may, the floor over to Wendy, who has a professional engineer's report on Mr. Zappi's application that we'd like to share, which will raise some other issues which I think should be of interest to the board. Firstly, Mr. Zappi, I just want to address the fact that you're saying that the EAC is making these claims. From what I understand, and I think the EAC will back this up, there was a request to walk the property by the EAC, which was denied by you. Is that correct? Okay, no jury, but I'm just saying, so to tell them that it's not proper for them to give information without having walked it and then not allowing them to walk it, to me, is a reason for them to actually be allowed to walk the property and make their assessment. And of course, this is a very important meeting to establish the number of units that you claim as a maximum. We understand that it may not be the number of units that are accepted at the end of the day, but I think that at this stage, it's a very important, critical juncture in the evaluation of your application. There's a strong public concern about what might happen, and of course, once something is done, it cannot be undone. And we know, having reviewed and seen other projects that you've been tied to, that things don't always turn out the way that you may present. So,
I'd like to introduce myself. My name is Michael McDermott. I'm a litigation counsel for Mr. Zappi. I'm here to represent Mr. Zappi's interest as well as his company in connection with any of the comments that are made against my client or his integrity.
You threatening this room?
Sir, I'm addressing myself.
I think I understand English. You're threatening this room.
I'm addressing
no,
myself.
this is, no, I'm sorry. I retract what I said. I just want to say that.
No, I'm not finished.
Okay, please finish.
I'm here to watch the influence that is being placed on the board to make sure that the board makes a decision based on the merits of this application rather than necessary comments like what counsel just said, imputing the integrity of my client.
I'm not counsel, sir.
You made a comment about my client about other projects that things don't turn out. I take offense to that. I'm going to represent his interests.
I apologize and I retract that, sir. Okay? Please. Okay. So can we just stay to the...
The comments come to the board, not to the applicant.
Okay.
Should not be cross comments between people in the audience. Comments are directed either to the board and to the board only.
If I want them to answer, I will.
Well, you tell them. Okay. So I'm going to just turn this over
Well,
to...
Donna Sherrod has something she wanted to say first. She's unmute now.
I just would like to clarify. I'm with the EAC, and I just wanted to clarify that, yes, we did go over the maps, and that, I think there was a little confusion, because I don't think that Dennis's comments were referring to the previous map that we had already discussed, and I did, all of us did accept that discussion about the other map. I think what it is, what Dennis was talking about is the code that allows this board to request an independent
It already has.
review.
It already has done that.
But this is based on something that the...
We did a verification. We have a wetland specialist.
That verified this.
Correct. And we sent that to you at the EAC
And
Planning Board.
this shows
meeting.
all the wetlands 200 feet outside of the...
It doesn't show that one particular wetland that you mentioned. It doesn't show that one particular wetland. We know where that is. We understand that it's there, and it doesn't change any of the conclusions.
Well, I did not understand that you had someone else that went out there and verified this. Because what we looked at, we had an EAF that was incomplete.
We're just
and
talking about the
inaccurate.
wetland delineation now.
I'm just saying, this is the information that we were getting, so we are trying to look, and now there is another project in Ossining that has, a property has been destroyed. So when that happens, we want to just make sure everything's exactly the way it should be, and if it has to take a longer look, then I feel that that's what we're asking, is that a longer look be given to this project. And I did not understand that there was independent. Did you understand that there was an independent review? No. I did not understand that at all.
Yeah, I'm sorry if you didn't understand that.
I understood when you discounted the other map, and that I understand.
I don't mean to be critical, but we went through that part of it as well.
You said that we received information, but what information did we receive?
I don't recall receiving information.
I think we're getting a little bit too detail-oriented at the moment. I don't mean to shut you down, but we're talking about the wetland delineation. We talked at that meeting about the mapping that the EAC was using.
We were also told we were going to get a new EAF, and that has not been received.
And you will not be getting that until after
Would you like to speak about the DEC, what they told you today?
the word goes to the applicant. If you would like to prepare the cluster based upon some number, at that point in time, the environmental assessment form in great detail will be submitted, comparing the conventional to the cluster. So we said at the meeting that eventually there would be an environmental assessment form. I think we also talked in terms of the timing of that new environmental assessment form. So again, I'm not quite sure why the EAC...
I don't understand how you can approve something without knowing all the facts.
We explained that as well in terms of...
I guess I'm just not, it just doesn't make any sense to me. I'm sorry.
Yeah, I think it might not be a bad idea to meet with the planning board again and have the same kind of meeting.
That'd be fabulous.
Going forward, we can continue to try to explain things as best we can. Try to bring the EAC up to speed. And again, I don't mean to be critical, but I thought we went through this.
Actually, on that note, on the EAF note, can you explain, well, first of all, has the action been classified as a type 1, type 2, unlisted action?
The position that's being taken is that at this point in time, looking at the conventional layout, coming up with some hypothetical, theoretical maximum number that the applicant can use to start designing a cluster if he should want to, is not an action that is subject to the seeker process. It's not an action that would grant any vesting to the applicant whatsoever. It's just a sort of a maximum theoretical, hypothetical number that he can start with. And that number could come down conceivably based upon factors that we learn going forward. And again, I'm not trying to be critical, but I thought we went through all this.
Can I ask a short question? So,
you have to direct it to the board.
Can I ask a short question? So based upon what the text of the letter, as I understood it, is that his plan has to comply with all requirements as if he was going to build it that way.
It has to comply with applicable requirements based upon a certain level of detail. And the zoning law is very clear, and the subdivision regulations are very clear about the level of detail for a sketch plan. It's not the same level of detail an applicant would have to go to submit and get a preliminary plat approved. It's not the same level of detail that an applicant would have to go to get a final plat approved. What is called for is a sketch plan, and the level of detail is very specific. So you go as far as you can in terms of the review based upon that specific level of detail.
So does the subdivision, does it also specify that the sketch plan and the cluster zoning should be submitted at the same time?
No.
Should be submitted together?
No.
No, because without the sketch plan, he has no idea how many units he can cluster.
So, is the environmental impact of the plan as designed here, the 20, whatever, the way he's got it now, are you saying that he doesn't need to fully vet the environmental impact of this plan?
Yes.
That's correct.
And it's specified which chunks of the environmental impact he has to meet and which he doesn't?
It's specified what level of detail has to be supplied, and that plan, it's called a sketch plan, and it's called a sketch plan for a reason.
No,
it's
I
a sketch.
I understand. There seems to be some confusion about
That
where
has
the
to
dividing
be,
line is.
That has to be, well, there's not confusion on this side of the room. That level of detail has to be looked at. That sketch plan has to be looked at. It's got to be compared to the regulations of the town regarding development, and a number comes out of that analysis. And that number is not locked in stone in any way. It's a number that is subject to change based upon future
But
and
realistically,
further. Let me just finish.
It is defining the maximum, right? It does define the maximum. This process.
It would define the maximum. It couldn't be exceeded. But it doesn't define the number that the project may end up at. It doesn't define it doesn't go beyond what it's intended to do. And it's not a determination. It's not going to be done by resolution. It's not going to grant investing to the applicant. It's just going to be a number which he can go away with and come back with a cluster if he should want to do that, with a full environmental analysis of that cluster, comparing it to the impacts of a conventional.
Wendy?
If I could add something, because I've been involved in all these discussions from day one as well, and I spoke at the town hall meeting on this, and we've had many discussions about this fact. I found it very interesting as well, and I wanted a better understanding myself about the process, and which caused me to do a little bit of research as well. And I think that there is some basic misunderstandings, and I think the board has tried many times to state that what's being done at this point is not going to vest any rights in this applicant as far as an absolute number. And I understand the process, and I understand all the comments, and I understand where they're coming from and the basis, and I understand that there are reasonable basis for a lot of the comments as well. However, there are some legal standards that do exist in terms of determining lot counts in a cluster subdivision. And what David has pretty much said is correct. And your point about what environmental considerations you do apply and restrictions is a very interesting one. It's something that I did grapple with myself. And essentially what I have found in terms of case law is language which does define it to a degree, because really what it comes down to is this: at the sketch phase, the sketch is going to submit basically a drawing, obviously, and it's supposed to submit a drawing which covers property which is suitable for development. And there are certain subtractions that you are allowed to do for purposes of determining what's suitable for development. Certainly roads, if there's any stormwater detention that's required or necessary, that could be a necessary subtraction. But essentially, it's if I can find the language that I was looking at before, it has to do with when you're talking about what's unsuitable for development, you have to look at what the laws actually restrict, what they actually do restrict and say you cannot build on. It's not necessarily a determination at this point about what you think you should not build on. It's what you specifically cannot build on. Because, as Mr. Ciarce has determined, and he's stated in his report, and I'm seeing this report today for the first time myself, what he's stating is that there are certain challenges in terms of development, perhaps, but if it is technically achievable, and this is directly from case law, to build, even though it has difficulties or maybe it has to be looked at more carefully, it's not considered for purposes of determining lot count to be unsuitable for development. It is my conclusion based on my research. So I think we have to look at it that way, that there's going to be further reviews, but as has been stated innumerable amount of times, this is not the final review. This is a very limited review. What we're looking at today, based on my review of the law and the way the courts have interpreted, because these cluster subdivision regulations exist virtually identical in terms of language, in terms of how these statutes require these developments to be reviewed. We're looking at what is, quote unquote, technically achievable. So if you're talking about steep slopes, as Mr. Ciarce says, you're not prohibited from building on a steep slope. You may have to take certain steps, you may have to go through certain reviews, and the same thing with wetlands. Again, it's a matter of what is technically achievable. And it is not a matter necessarily of saying that we would prefer not to build it there because we think that there's going to be environmental problems.
I understand that. So the question again comes back to at what level of environmental impact review is required at this stage
I think what I
None?
just said is very minimal.
No.
No, I wouldn't say